I tend to try to treat child pornography cases that I know are going to be damage control cases, kind of like I'm dealing with someone that has a drug or alcohol addiction problem. Now, in some cases, it's not the case where it's damage control. I have a client that's come in that says, I'm not in possession of this, or they violated my client's rights. Even in those cases, it's important to follow the path as though you're going to be sentenced in your case, because there's no guarantee you're going to win or lose at trial. You at the very least want a mitigation defense at sentencing. In some cases, I tell clients, you could go through all of this treatment that I'm recommending that you go through, and at the end of this case, we could win it and you did it for yourself or for nothing. But at least we had a backup plan. What you don't want to do is you don't do any of the stuff that I tell you to do because you say, I'm innocent, and I get it. You're innocent, but you got to have a backup plan. So if we get to the end of this and we fight and fight and fight, and it just unlikely doesn't just go your way, and then you're going to be stuck in front of a judge that you just fought a case out on, potentially lost, and now you're in front of him with nothing except, can you please just be lenient with me? And that's not a good spot to be in. Now, some common defenses is number one, the search warrant. It's very rare for me to see any problems in these search warrants. The reason being is that most of these cases arise out of ICAC or FBI or Homeland Security monitoring certain websites, file sharing programs, and they literally just download it straight from your IP address. And you're never usually going to win on those bases. The cases that have the highest chance of success with a defense is usually that you did not intentionally or knowingly download this material. A common scenario is you're on a file sharing program, Pirate Bay or Torrent, whatever it might be, and you are downloading packs of videos. And let's be real, lots of people download pornography, but sometimes when you're downloading pornography, you could be downloading off these file sharing programs very illicit, illegal material. And sometimes it's done in packs, so you can't see every single thing that you're downloading. So unbeknownst, in some of my clients' cases, they've downloaded material, and it also happened to have been monitored by ICAC or the FBI or Homeland Security, and then they get a search warrant, and they do find child pornography on this computer, or they find the download, or they might find a deleted file. And while we're on the subject of deleted files, just because it's deleted does not mean it's deleted. In the defense that I'm talking about is when you unknowingly downloaded, later found that out what it was, and then deleted it. There is certainly a defense that you did not knowingly or intentionally intend to possess this material. This is the complexity in that argument, is that if you choose to go to a jury trial on a child pornography case with that argument in defense, which I think is a very legitimate defense and very realistic, it rolls back to the cultural stigma issue. If a jury walks in there and learns that they're handling a case that involves child pornography, and a prosecutor shows on a screen some horrific sexual act being performed on some juvenile, it can be hard to get them in your corner. And the cultural stigma of it doesn't allow them to keep an open mind to our arguments. If we had a fair and impartial and people that could separate that stigma, it would be a good case to go to trial on every time. But the most important thing is that we know these things, we're educated enough to think this deeply into it, and we allow you to make educated decisions as to whether you want to take the chance at trial with that type of argument, knowing what we're facing. Another common defense in child pornography crimes is the images themselves. Oftentimes, I see cases where a client is accused of being in possession of child pornography, but it might not actually be child pornography. There are legal sites that have categories, legal pornography with teen categories on there that attempt to make women look under the age that they actually are. In some of these cases, I'm seeing images that questionably might not depict someone who is under the age of 18, which would constitute child pornography. This is another mistake that inexperienced child pornography lawyers make. They read what ICAC or Homeland Security wrote in the report and never go view the images or videos themselves at the prosecutor's office. Couldn't make a bigger mistake than that. Now, some of these are not arguable because there is a database of children that are identified victims of sexual exploitation, and those are not arguable cases. But there are a number of cases where we'll get them and they're not identified in this list, and I have to view these images and videos to make sure that there's not an argument that could be made that this person isn't under 18. The last most common defense is that I was not the one that downloaded this material to the computer. There's more than one person in the house. There's someone that has access to my computer. This wasn't mine. Those are very difficult cases as well because, of course, no one else is going to want to say that it's their material. But it is definitely a legitimate defense and can be effectively asserted on a case-by-case basis.